Hello everyone, it's Wayne Jones, the course coordinator for Australian Employment Law. This is week 3 and look, an apology. Once again, there's enough material for me to do 2 short presentations for this week, just so that we can keep the presentations relatively short. So this week, I'm going to concentrate first of all on Chapter 5, and then in the next recording session, I'll talk about Chapter 6. Now, I found Chapter 5 to be interesting, but it seems at first blush to be a little bit disordered. And then I gave it a rethink, and this is my take on the material for Chapter 5. If you have a look at the opening comments about hire and employment contracts, and the idea that you can employ people on whatever terms you like, predominantly because, after all, an employment contract is still just a contract. So you can employ people on whatever terms the two of you can agree on. That would seem to be the situation in every contract. And the reason I say that is, for example, if you've done any contract study so far, you'll know that it's open for people to make a bad bargain. The court won't interfere with a contract after the event simply because you say on reflection, oh look, I think I made a bad bargain. It is open for people to enter into a contract on any terms and conditions that they like. That's business. That's just how business works. So taking that to an employment situation, that would mean you would think that people could, if they wanted to, for their own motivation, maybe work's really difficult to get, whatever, they might just happen to say, well, look, we'll bargain on less favourable terms. So there shouldn't be any impediment to not only to hiring whoever you like, but to hiring on whatever terms you like. And so the rest of the chapter then deals with the reasons why that's not the case in employment law. The comment is made early on, for example, that any attempt to limit who you can employ and under what circumstances might be seen as a restraint of trade. And we talk about restraint of trade later in the course. But overall, we're now going to talk about the reasons why an employment contract is different to other contracts where you should be able to contract on any terms that you see fit and hire whoever you like on the terms that you see fit. Well, one of the first statutory restrictions that comes to mind is the accreditation process. So in the accreditation, by the accreditation process, I mean that people like myself, solicitors for example, need to be accredited. So I can't hire someone for my law firm to be undertaking legal work for me unless they've got the right accreditation. So that's a good example. Another one is that from a statutory perspective, some jobs will require that the person that you're looking at has a blue card. In other words, they've got approval from whichever body in your state deals with child protection. And that's a copy of the back of a blue card which I have. So it's a card which I would need to produce when I'm working for a child-related organisation. So again, it's another time when what we're talking about is a restriction on that overall proposition that you can hire whoever you like on whatever terms that you want. The textbook mentions slavery. Look, it's a little bit, I think it's a bit out of context, but in any event, I'll make a comment about it. Have a look at the legislation. There's a Crimes Legislation Amendment Act that I've got up there on the screen there, dealing with forced labour, which is probably, I think, a bridge further than what we're talking about. So, as I say, it's perhaps a little bit well, away from what we're discussing in this particular chapter. All right, well, look, there is a mention also of child labour. So again, I'd like to hire whoever I like, and I would like to hire as cheaply as I could, so I think I'll hire child labour. Well, the state legislation deals with the hiring of child labour, and that includes situations where the person would ordinarily be a national system employee. So interesting, it's one of those exceptions where the state law still applies. You'll see that, have a look, for example, at section 27.2e and 29.2b, which deal with the fact that the National Employment System employees, modern awards and enterprise agreement are still subject to laws regarding child labour. The only exception is that not so far as the child labour laws might start to talk about employment conditions. So principally about things around times and how long children, that is, people who are under the age of 16, can be employed. There are some exceptions. Your textbook mentions them. I guess the most notable one for me is that it's still possible for kids to work in the family business. Now, another exception to I can hire whoever I like, foreign labour. Quite contentious, and you'll hear a lot about it in relation to two topics. One is the hiring of people who don't have the right visa for work. So you might have a young person in Australia, for example, who's here on a tourist visa. They're not really supposed to be working at the same time. That was the situation, certainly in relation to employment in the rural and in the fruit picking and fruit growing area. It's constantly a vexed issue for the government. So the terminology is that a person who's here is an unlawful non-citizen, meaning either they haven't got the right visa to do what they're doing, or they had a temporary visa and it's now run out. You'll hear, for example, that our international students are entitled to work for about 40 hours a week when they have a student visa, and they're always a little bit touchy about whether or not they're exceeding their hours. A couple of years ago, and it's a bit further back than I remembered, but 2007, there was a lot of fuss, again in the rural and regional areas, when the law was changed so that an employer who knew or was reckless about employing an unlawful non-citizen all of a sudden became liable for a criminal penalty. Now, that also meant labour hire companies. So if you had a labour hire company that was employing people who didn't have the right visa, they were also liable for a penalty. Also, just in relation to foreign labour, have a look at the commentary in your text around 457 visas. You've probably heard that term, 457 visa. I've put a copy of some of the information about 457 visas up on the web page. Really, it's a shorthand description of what is a temporary, it's a visa for up to 4 years where a person could come to Australia to work. The purpose is that they're here to fill an unmet need. So the government has allowed that if you were, and I'll just pick one that I'm aware of in recent times, if you were a vet and you were happy to come to a regional area to work, there's an unmet need for vets in the region. An employer in, say, Winton or Longreach or Emerald or somewhere could apply and sponsor a vet to come and work in their veterinary practice for up to 4 years. But there has to be an unmet need in the local labour market. And it is always a temporary thing. It's not like a backdoor to coming in. The person is hired under a particular contract for a certain period of time, and they're given a visa to go to that particular job. A couple of issues, I'll just go back to that one. A couple of issues which have arisen around these visas is the unions have claimed for a long time now that the testing is not really happening. That is, the testing of the labour market could be a lot more rigorous. Obviously, they're keen to have Australian workers who are looking for work employed before other people are imported to fill positions. And there's been an ongoing issue in some areas, not so much in the professional areas, but in the semi-skilled areas, so meatworks and that sort of thing, a temptation to underpay workers because they're totally unfamiliar with the system. So there's also a commentary, I think, in the text about the fact that different governments treat these visas differently. There's been some freeing up. under the Liberal National government, they're more interested in freeing up the process so that it can happen a lot more smoothly. But at the same time, there have been increased penalties for people who take advantage of the system. My own feeling is that we'll continue to use these skilled worker visas for into the future, because they have certainly proved to be very popular with employers who can't fill particular roles in the workplace because of an unmet need locally. Now, another reason that you cannot just hire and fire as you see fit is you can't do it in circumstances where your decision making is driven by discrimination. So, for obvious reasons, you don't see ads that say only white people need apply, or you don't see ads that are very specific about age or gender, or no disability or no union members need apply. More about that a bit later on, but I guess it's just stating the obvious that you don't have an unrestricted capacity to hire who and on what terms you like if one of the restrictions is discrimination. The other side of that discrimination coin is this issue around affirmative action. Now, just two points to be made about this. Not a huge burden on employers. For a start, you need to have 100+ workers before the legislation applies. It's the Workplace Gender Equality Act. It's more about reporting than it is about reaching or failing to reach a quota and then there being a penalty attached. Have a look at it for yourself, but it is for much larger companies. It's a slow push in the right direction, asking employers to at least report on a regular basis about some of the gender equality indicators. So, are women and men receiving comparable wages within the firm? What's the makeup of the workforce? If it's biased towards one gender, why? Is there a reasonable makeup on the board of people? Like, is it a fairly broad church? And do you have family-friendly policies in the company? Have a look at the Act. But again, another reason why you can't always hire and fire whoever you like. All right. Now, the text refers to some of the paperwork that needs to come with this new contract of employment. We're looking at creating an employment relationship, Chapter 5 in the textbook. So, what sort of paperwork needs to come with it? Well, the National Employment Standards require that a statement be given. So, I've put up a copy of it on the website. Essentially, Section 125 of the Fair Work Act says that a statement be given to new employees regarding their rights under fair work. Interestingly, the Act also says that, I think it's Section 124, but have a look for yourself, that you only need to give one copy each year. So I'm presuming that would refer to situations where you might have a workforce that is either casual or they work a series of short-term contracts. That'd be likely, for example, here at the university. We have people who work for us for a term and then they'll have a break and they come back. The NES only requires that statement be given once a year. All right, well, in making the contract, talking to people about taking up a job with you, what can't you do? What are some of the things that you can't do? We jump quickly from the Fair Work Act to the Australian Consumer Law, and the text refers to the two sections that are of particular interest. Now, the first one's a bit of a no-brainer, and that is the section which talks about misleading conduct relating to the making of a new employment agreement, so availability, nature, terms or conditions of employment. So this is where, in relation to employment that's about to be offered to someone, you make misleading statements about any of those things, availability, nature, terms, conditions, or any other matter relating to the employment, and you can be fined for doing something to the contrary. So that seems easy enough, and I think the textbook gave you an example of a case there. The more tricky one is the section which used to be section 51 in the old trade practices, and that's about corporations not acting in a misleading or deceptive manner in trade or commerce. So that's usually about a broad variety of things, including false advertising, etc. But generally, the trick with employment is this issue about in trade or commerce. Have a look at the cases, particularly in the pre-employment area. Have a look at Bartow against GPR Management, and you'll see that that's a case, in fact, where the person is being offered a change in conditions, but it fits the same category. That is it a variation? It was a variation to contract terms, so essentially it's a new employment. So have a look at that one, and I'll highlight some of the other cases that I think are worth looking at in a second. But before I do, just be aware that the courts seem to be taking the view that Section 18 is a bad fit, unless you take a very broad view of what in-trade or commerce means, and they've said, okay, well, pre-employment, I guess, is part of in-trade or commerce. But be aware of these other sections. So, two worth a mention. One is if something is said about, for example, future earnings, but talking about what's going to happen in the future, Section 4 gives the person a defence if it was done on reasonable grounds. So if things didn't come to pass, but the person who made the representation had reason to believe that they would, then that might be a defence. And the second is, note the comments in the text, particularly regarding directors and officers of the company. They might be liable for breaches by the company. So Section 5 or 6 in the Competition and Consumer Act says, well, breaches by a company might also include breaches by directors and officers. And note the commentary anyway that where the consumer law has been imported into state legislation, that has a broader ambit anyway, as we know from our discussions in the first week about jurisdiction. It might also apply to a person rather than just to a company. Okay, the cases, I'm not going to labour these, but I would ask you to have a look at them. Do have a look at these cases on misleading conduct. Have a look at Holloway, Concrete Constructions, and Bartow that I just mentioned a minute ago. And the citations for all these are in your text. For cases around defences, have a look at Harris and Linfox and Keys and JP Morgan on that issue that I just mentioned about Section 4. How did you come to have reasonable grounds to make that representation? That was, by the way, that section was one of the ones that's you'd see it often used in cases where someone was induced to buy a business, like you might buy, say, a transporting business where a representation is made as to future earnings. The person might say, look, I've been making $10,000 a month with contract work. The purchaser just doesn't realise that sort of money. Then the only basis for a defence that the seller had was to say, oh, look, it was on reasonable grounds because I was actually making that much money. So it's a section that comes up often. And just on misleading and deceptive conduct compensation cases, there are about 3 or 4 of them mentioned in your text: O'Neill, Walker, Moses and Metz Holdings. Let's have a look at those. Again, the citations for those cases appear in your text. Harking back to what we were saying before about discrimination, anti-discrimination legislation, there's certain things that you just cannot ask about. We're looking at the Disability Discrimination Act, so not the Queensland Anti-Discrimination Act, but I would urge you to have a look at your legislation in your own state. The textbook authors refer to Section 30 in the Disability Discrimination Act, which is a Commonwealth Act, and it says in a very convoluted way, have a look at the drafting, it's pretty appalling, but it says in a convoluted way that you can't really ask for generic information, as in, by the way, information. Oh, are you married? Are you gee, how old are you? Are you a Muslim? Are you a Christian? You can't ask for that sort of generic information. It's just not allowed, because it would raise the prospect that you might be using that information to make a decision about employment. So it's silly. You wouldn't do it. And you'll see a case referred to in the textbook where Woolworths was slapped over the wrist for doing just that. So you can't just ask for that generic information. You have to just ask questions that relate to an inherent requirement of the position. Now, obviously, you could ask about sex if an inherent requirement was, say, a woman to work in a girls' dormitory, for example, and the preference was to have a woman to be in the dormitory with young women. You felt that was an inherent requirement. But yeah, you can't just ask them because you think you're curious about it. Secondly, just do consider the comments that are made there about spent convictions. That's something that's, I guess it's been around for a few years now, but a lot of people do tend to ignore that still. And a word of warning from me about that. There are still some instances where spent convictions are relevant. Now, as a former criminal lawyer, I can tell you that if a person appears in court, their entire history comes up before the judge. So spent convictions doesn't mean the slate is wiped clean. It means that for employment purposes, at least, you don't need to mention them. Now, we're on the downhill run. I mentioned at the outset a contract is always a contract. So even if it's an employment contract, it's still just a contract. So if you've done any work already with us in the area of contracts, a lot of this stuff is going to be already known to you. I'm not going to labour it too much, but if I said a contract is still a contract, it still means that you still need to have offer and acceptance. So it still needs to be fairly clear that you have an agreement between the parties. The parties are of one mind. They do intend to create a contract of employment. There needs to be some consideration, and that means it's flowing from the offeror to the offeree. In this case, it'll be wages, and an intention to be bound. So we're not still at the discussion stage. We're still not just talking. We're not exchanging ideas about how the contract might look and how it might be formed. We've got to the stage where we intend to be bound. Interesting point, this one, because there's more flexibility in employment law contracts than there are in other contracts. For example, contracts for the sale of land. Have all of the necessary terms been agreed? In other words, is there some certainty about it? And you'll see that there is flexibility around, in the next chapter, you'll see there's flexibility around issues like how long is the contract going to go for, and what are the wages going to be? Because although it's usually foremost on people's minds, strangely enough, sometimes those things aren't agreed. And is there anything in the contract which might be illegal? So far as the intention to create legal relations is concerned, look at the cases, particularly have a look at that Teen Ranch case, because it's quite interesting, and it's referred to a couple of times. Essentially, sometimes you can see it a little bit difficult to differentiate it, for example, with some of the other cases like Redeemer Baptist School, because it's what the judges are saying is, well, there was never really any intention to create legal relations. Doing what he did, being there on the property as a caretaker, he didn't have to do anything other than that. That wasn't the sole basis on which the relationship was based. But have a look at it. And Neilton Matheson we looked at already. That was in week 1, and that was the case where the lady ended up working in the shop after she separated, and they ended up in a big fight over whether or not she was an employee or not. But bear in mind the comment there that always applies to all contracts, and that is, it is an objective test as to whether the parties intended to create legal relations. It's no good being subjective and coming along to the court and saying, oh, well, I intended it to be binding. That was my view. That was what I intended to do. The court will have a look at whether objectively someone else looking at it would come to the same conclusion. Some interesting comments about work experience. I thought these, that's certainly worth a look-see, because some of you at some stage will be perhaps considering taking up some work experience somewhere. Obviously, having paid work is part of consideration. So what's the situation with work experience? Well, the question is essentially, is the worker, is it paid work or is it exploitation, even if there are identifiable educational benefits? So again, it's an objective test. People look in from the outside to see, does this actually look like work, or does it look like short-term work experience? Great description. I think it's in your text, but if not, it might be in one of the cases where what's said is you're looking to see whether what's being done by the work experience person really could or should be done by an employee. The case that was referred to was Crop Media, where Fair Work Commission had a go at a company called Crop Media, and Crop Media put their hands up and they said, well, yeah, we didn't mean to enter into an employment relationship, but the reality was that it had just gone on too long and they were really performing work which could have been done by an employee. So an objective test, does it look like work, or is it really just an opportunity for somebody to observe, to watch, to see how it all happens? And another really big point, strong point, is it part of your university course? So if you're going to get marks for it, or if it's been arranged by the university as a short-term try before you buy, whatever, then that's probably going to be work experience. Have a look at those sections of the work of the Fair Work legislations, 13 and 15, 30C, 30M, and that case that's mentioned in the text, Upton and Geraldton Resource Centre. So far as certainty is concerned, I mentioned this earlier, it's one of these contracts are the type where the courts will intervene and come up with some conditions, some terms, which would ordinarily, you'd think, would be very fundamental. So if you didn't have an agreement on how much to be paid or how long the contract was going to go for, in any other contract, that might be enough to have it knocked out. But if there hasn't been agreement on those items, the court will go a fair distance to infer reasonable terms. So how much will I be paid? Well, it's a reasonable inference that you'd receive the award, or whatever other people are receiving under an enterprise agreement at the same workplace. How long is it going to run for? Well, we haven't agreed, so it's pretty much open-ended, and how much notice you'll receive to terminate your contract will be, I guess, dependent on a couple of different factors, but you'll receive reasonable notice. That might be in your enterprise agreement, might be part of the common award, or it might be otherwise allowed for in legislations, for example, in the employment standards. The one that was more problematic was, if I'm going to receive a bonus or incentive, how do we calculate it? And the courts have shied away from that. You'll see examples of why that's so in the text. And there are probably other examples of conditions that are a bit of a bridge too far for the court, so they won't really intervene and infer reasonable terms. So far as illegality is concerned, it rubs up against public policy. Now, you'll see, you can imagine that a person who was here illegally, for example, an illegal entry, the non-citizen we talked about before, who was working here illegally, the cases are a bit divided, and have a look at some examples, but I think as much as you really need to know is this: the public policy aspect is to suggest that, look, sometimes that would be to give the wrongdoer an unfair advantage. And the example that was given in the text is that some of the workers' compensation legislation throughout Australia talks about the fact that, all right, if someone's injured at a workplace, and even if they're there illegally, they may still be entitled to workers' compensation. They may still be covered. And that's really a public policy issue, which moves away from the general proposition that an illegal contract can't be enforced. So that's an example. And another one would be workers in the sex trade, so sex workers who all of a sudden have that thrown back at them to say, well, you're an illegal enterprise of some sort, therefore we're not going to pay you. For public policy reasons, those contracts may well be enforceable. Other examples that were given in the text that were quite useful were penalty clauses, unreasonable restraint clauses, and contracts where a person has agreed to accept less than the minimum entitlements. Now, remember I said to you before, right at the very beginning, there's no reason why people can't contract to take to come up with a bad bargain, and that would be a bad bargain if I said, look, I'm desperate for work, I'll take less than the minimum entitlements. Well, the reality is that can't be done. That is illegal. There is a public policy reason that that contract won't be enforced. Again, just like any other contract, there are various factors which can make the contract voidable by one of the parties. I'll let you read through those in more detail yourself, but they're pretty much straight out of the contract textbook. So if there's been a misrepresentation, if there's been a mistake, there's been some duress or some undue influence, or one of the parties was under a serious disability, and it would be unfair to insist on the contract being carried out. But look at those in more detail. They're straight out of contract law. There was a question thrown up about which employer. I think we'll talk about that more later in the course, particularly where there's a transfer of business. But for now, the general proposition is if there are a couple of contractors, or if there are a couple of employers, a couple of companies that could reasonably have employed a person, and it becomes a real issue as to who the real employer was, the courts will look at the totality of evidence to decide. The employer might choose initially to say A company will be the employer, even though B company is perhaps the larger of the two. But once they've done that, they can't start moving people around just because it suits them. Usually because they may be trying to, or the courts might be concerned that they're trying to avoid a payment or avoid paying out a person's entitlements, particularly if one of the companies has gone broke and the other is still healthy. So courts will look very suspiciously at moving people around within a corporation. But as I said, more later when we look at transfers of business. An interesting quick story about that, though, about employers moving people around. Occasionally, particularly in the rural business, I've seen this happen, where stupidly an employer will suggest that you're working on the same farm doing the same job Monday to Wednesday for company A, and then you'll finish up, and on Thursday, Friday and Saturday you're going to start working for company B, so that you don't exceed the maximum number of hours in a week. Well, that's clearly a sham, but strangely enough, there's been examples of that again this year, 2016, so they keep coming up, but you get the point. All right, look, that's my comments in relation to Chapter 5. I found it pretty interesting, but to try and keep it together in your mind, just remember the initial slide, which was and my initial comment, which was you start from the proposition that you don't want to have a restraint of trade, that people should be able to contract on whatever terms they like, and they really should be able to hire whoever they like, and then the rest of the chapter deals with exceptions to that rule. So that makes a bit of sense into Chapter 5. Look, again, apologies, but there was enough material in there to take up 20 minutes, so or half an hour. So I've put the comments in relation to Chapter 6 in the next presentation. Thanks for listening.